No, why should we interfere with this?
Your Lordship, I will just make my submission, Your Lordship. Your Lordship, the Honorable Single Judge has allowed it on two grounds. Firstly, that it has not been backed by a decision, that the decision of demand was not backed by a decision of the board. And secondly, on a writ application which was passed by this Honorable Court. Your Lordship, in both the grounds, Your Lordship, the first decision was not required because clause 15 of the agreement, the terms and condition which was reduced in writing in the hire purchase agreement was binding with the board and the petitioner, and it was that board gives land to landless people, homeless people to live, not to earn profit by selling it. From the very facts of this
Who
case,
sold it?
they are selling it. That is the reason they are
No.
transferring it to somebody else.
No.
And that, Your Lordship, may understand the fact, may appreciate.
That's not there in the order.
No, that is there. Labhansh is only, what is Labhansh? Labhansh is 50% of the unearned profit, which for transfer. The petitioner has
Now,
said,
how do you know? Just a minute.
Your
Don't
Lordship,
get-
that is the case.
Please don't get excited by the question of the bench. Try and understand.
Ji.
Court is only trying to elicit
Ji,
information.
ji.
I mean, staying calm at that place would make you respond to the queries of the
Lordship.
court in a better
Your
manner.
Lordship,
Now, they are going to sell the property.
Your Lordship,
How have you assumed what would be the price charged by them?
that the
Then how do you calculate 15% of an indeterminate amount and you charge him? That's what we want to understand.
Your Lordship, whenever there is a permission for transfer of the land apart from blood relation to any other person,
Apart from?
blood relation.
Yes.
If the transfer is to blood relation, the board doesn't interfere. But when it is for profit and selling it to, then 50% of the market price of the plot, the board charges, and 50% profit the person who's the allottee keeps it. And this value is as per the market price. So the clause also says, clause 15 of the hire purchase agreement also says that
We
50.
have followed that.
Ji.
We are asking you something which occurred anterior.
Your
to
Lordship,
what you are-
50%
what
of the
this
market price, whatever 3 kattha
case. Now,
zameen
where
hai,
in the judgment spanning in about 10 pages, I did not find anything which would give an impression that the property was about to be sold. And you had an idea of the price which is being charged by them.
Your Lordship, they sought permission for transfer of
Where
the
is-
land.
where is
That the letters of the petitioner, Your Lordship, the basic writ is for that. That they sought permission to for transfer of the.
Show us.
Your Lordship, that is an
Mr.
extra
Singh, are
5.
you selling the land?
Yes.
Are you selling the
In
property?
the agreement itself, it is mentioned as.
No, agreement is all right.
Ah,
For the agreement was in the name of your father died, you got your name
Yeah.
substituted, you paid the money, you offered all documents, 2010, everything was over.
yes.
Now, are you selling the property?
Yes, transferring to some third person,
Not a blood relation.
not a blood relation.
Not a blood relation.
Yeah, therefore I will have to pay 50% of the premium. And they have charged it and I have paid it. Lordship may kindly see page annexure 6 of the writ application.
Page?
Page 39, Lordship. They have asked for the balance of cost and the premium. 7,70,000, that has been paid.
तथा भूखंड की कीमत के विरुद्ध कुल इतना रुपया तथा इकरारनामा की कंडिका 15 के प्रातः लाभांश के मद में, तो ये लाभांश आप कैसे कैलकुलेट करते हैं?
ये
मार्केट
जो
प्राइस का 50%।
उस मार्केट प्राइस जो भी उस समय प्रिवेलेंट
उस ईयर का 8-9,
हाँ,
because
जो भी।
after 8-9, Your Lordship, the market value
तो
of
ये
the
तो
land
जमा कर-
escalated.
Just a minute, ये तो आपने जमा कर दिया ना 7 लाख
हाँ,
Your
जमा
Lordship.
कर दिया।
ये जमा कर दिया।
जी।
अब आप
This
क्या
is the
मांग-
catch. This is the catch, Your Lordship. The
catch
honorable,
है?
the honorable court had.
बैठिए Mr. Singh, let her
The honorable court has relied upon a judgment wherein the petitioner.
आप हमें जजमेंट वजमेंट छोड़िए
Your
ना।
Lordship, that is-
यहाँ जजमेंट से
Your Lordship-
जजमेंट तो डिफरेंट फैक्ट्स पे जजमेंट होता
हाँ,
है।
नहीं, but-
यहाँ के बारे में बताइए ना।
Your Lordship,
ये
जी।
लाभांश आपने चार्ज कर लिया, इन्होंने दे दिया।
No, so dates, 3 dates may be noted, Your Lordship.
Yes.
Only 3 dates.
Yes.
The demand was made on 24/11/2009.
हम्म,
That you deposit this amount, then we'll consider. Then we'll consider. This is the
Yes.
letter of 39 which Learned Senior Counsel has just read. Then the first payment was made on 24/5/2010.
फर्स्ट पेमेंट मींस
The 5,22,000 was made on 24/5/2010. And the second payment of 2,50,000 was paid on 28/9/2011. So he took 2 long years to make the said payment. So the financial year on the date of which you make the payment that year you are selling. So when you are selling in 2011, the cost of the land has gone very high, Your Lordship. And on that day, whatever the market price is, on that day permission would be given on the market price of the land. And Your Lordship, in the case in which the Honorable Single Judge has referred, in 15 days the payment was made. The board had taken 2 years to give the permission. But here is just the opposite. 2 years has been taken by the petitioner to make the payment of the demand, and thereafter the relevant rear market price was calculated. 3 kattha, 3600 square feet of land, whatever.
Where is that other notice? The later notice? You must have put him to notice that now 7,70,000 is not good enough.
Your Lordship,
You
that
need
is
to
the
give more.
impugned, that was the impugned
Where is
order,
that?
Your Lordship.
Show us from the.
Annexure 9, page 42.
Your Lordship, annexure 10, Your Lordship.
No, 9.
नहीं, annexure 10 है.
10 दूसरी चीज है भाई.
उसमें भी ये वो चीज क्लियर किया हुआ है. उपयुक्त विषय आपका आवेदन में कहना है कि बोर्ड का मूल सूद मद में इतना रुपया पावना संशोधित की गई, जिसके विरुद्ध इतना रुपया आपने जमा किया है लाभांश की सूची में सो एंड सो. लास्ट पैरा, बोर्ड के पत्रांक सो एंड सो द्वारा पूर्व में जमा लाभांश की राशि का सामंजन करने से वित्तीय वर्ष 12-13 का बाजार मूल्य के आधार पर 66 रुपया पावना संसूचित की जाए, जिस पर आपकी आपत्ति जताते हुए निरस्त करने का आवेदन दिया है, जो मान्य नहीं है. तदालोक प्रबंध निदेशक महोदय द्वारा आवेदन अस्वीकृत कर दिया गया. What I wanted to place before your lordship that the board had clarified it that now in this year the value of the land is may be very high. 50% of that is 66, and therefore you are required to, when you are selling the land in this financial year, the 50% of the profit market value is to be given.
It's a vague notice. Now, just a minute. The first notice dated 24/11/2000, the first demand notice dated 24/11/2009,
Your Lordship.
he was required to pay rupees
7 lakhs and odds, Your Lordship.
no 2,82,000.
No, 7 lakhs and odds. 2 lakhs and odds
कुल
towards
7,000 है. आप सुनिए ना एक मिनट.
7 lakhs.
2,82,225 रुपया लाभांश और भूखंड की कीमत 4,88,000.
That was due with respect to the
That's
cost
right.
of the land.
So that totals to 7,70,000.
जी हुजूर.
पता है मुझे.
Your Lordship.
दोनों डॉक्यूमेंट देख रहा हूँ.
जी.
आप फिर कम टू पेज 44 annexure 10.
Your Lordship.
The first paragraph. लाभांश के मद में संसूचित पावना 2,82,225 के विरुद्ध आपने मात्र 2,50,000 रुपए जमा की है,
जी.
जो वित्तीय वर्ष व्यतीत होने के बाद तथा अपर्याप्त राशि है. तो ऐसे भी 32,225 इन्होंने कम जमा किया था.
That was with respect to that financial year. Yes, Your Lordship.
अरे बड़ा मुश्किल है. उसी फाइनेंशियल ईयर का ना नोटिस के अगेंस्ट में जमा किया.
जी.
आप यू आर चार्जिंग because it was deposited in 2011,
Your Lordship.
right?
Your Lordship.
But according to the demand notice of 2009, he made less payment of
Your
30
Lordship.
lakhs.
Your Lordship.
30,000.
Your Lordship.
30,000, not 30 lakhs.
Your
30,000.
हाँ.
और वित्तीय वर्ष व्यतीत होने के बाद तथा अपर्याप्त राशि है. इसको कैसे पढ़ते हैं आप? 30,000 रुपए, 32,000 रुपए उनका कम था. बोर्ड के पत्रांक, अब नेक्स्ट पैराग्राफ, बोर्ड के पत्रांक सो दिनांक 11 द्वारा पूर्व में जमा लाभांश की राशि समंजन करने पर के बाजार मूल्य के आधार पर 66 रुपए संसूचित की गई है. 66 लाख रुपया क्या चीज है? बाजार का मूल्य.
Yes,
जो
Lordship.
आपने 4,88,000 चार्ज किया था इनसे.
No, that was towards cost. That was towards the cost of the land, and 2
भूखंड
lakh.
की कीमत.
जी, that was so the now the भूखंड की कीमत has gone to a very escalated amount, and 50% of the value is to be given.
नहीं हम नहीं समझ रहे हैं.
Your Lordship, if the value of the land is 50 lakh rupees per 1,300 square feet, that is 3 katta zameen, then it comes to 1.5 crore land value as per the market value. So the
No,
Therefore-
this calculation you have, annexure 11 is the calculation.
no, Your Lordship, what
Now
I
let us
simply
see what is the calculation.
this, Your Lordship, the counsel for the petitioner has. He has,
बड़ा vague सा है आपका
This is-
statement. Where is the calculation? How do we know?
market value, Your Lordship, is
Where, show us what is the market value, show us the circle rate. And why should we allow you to do all that?
that is the part of the agreement, Your Lordship, and that is, this has been held by.
तो आप अपने मन से कोई figure ले लेंगे कि यही है.
No,
आपकी
Your Lordship, the
calculation.
market value
Are
is
you
not one thing
supposed
that
to-
we can.
Are you not supposed, Mr. Shravan Kumar Singh may not have asked from you. I mean, his client may not have asked from you. But suppose some other person would have been the investor or the seller. He would have said that, how have you calculated 66,000?
The
Merely
market-
you are repeating that it is but pursuant to an agreement, clause 15 of the agreement, and the circle rate. What was the circle rate? Where is the circle rate notified for this 2012, 2013?
Your
Unless you
Lordship,
say that,
Your Lordship, we have,
the court is absolutely right, single judge.
no, Your Lordship, but the court has held that market value of 8-9 we have to
दो
charge.
मिनट
That is not correct, Your
दो
Lordship.
मिनट
I,
clarify
what,
करो।
as Your Lordship has fallen,
Let
what
us-
Your
let
Lordship
us-
has fallen
let us
is
hear.
that
Let's
11-12,
clarify.
whatever the market rate was, that 11-12 we
Lordship,
charge.
Annexure
That-
6 is the demand. There is no stipulation कि कितने दिन में आपको जमा करना है. ये डिमांड है 7,70,000 का. अब नेक्स्ट
Mr.
डॉक्यूमेंट
Shravan Kumar, that was not the ground taken by the learned single judge. You are perfectly entitled.
हाँ.
We can hear you out on this. But this was not the ground on which learned single judge decided the application in your favor.
So,
All right.
since
So-
Lordship is hearing the facts.
Exactly,
so I'm-
exactly. So we are not precluding you from making that submission. But that was not the submission which you raised before the single judge.
हाँ.
Nonetheless, we
हाँ.
take it into account.
हाँ.
Now-
इसमें कोई स्टिपुलेशन नहीं कब
Right.
जमा करना है.
Yes.
अब Annexure 7 में हमने 4,68,000 जो इनका कॉस्ट है, उससे ज्यादा हमने 5,22,000 जमा किया है.
नहीं, आपने 4,88,000 के बजाय आपने 5 लाख जमा कर दिया.
भाई, 5,22,000.
That sets off, that takes care of less 30,000.
नहीं नहीं वो फिर हमने नेक्स्ट डॉक्यूमेंट देखा जाए. Annexure 7 है, हमने 2,50,000 जमा किया.
वही तो कह रहा हूँ ना
हाँ.
कि उसमें जो एक्स्ट्रा जमा की वो इसमें ऐड कर लें तो फिर वो
हाँ,
32,000 का लॉस नहीं है.
हाँ,
वही तो
कुछ हाँ
आप नहीं कर रहे.
हाँ
That's what I am saying.
जी that's it. So there is no dues. Annexure 10 में जो कर रहे हैं कि जमा ही नहीं किया, अपर्याप्त है, ये गलत है.
देखें सेक्शन वो ठीक है, हम समझ गए. सेक्शन 50, that's
Section 15
Bordello
of,
argument that you made. Now let us
Section
see the
15.
agreement.
Your Lordship, page 25,
Of the
29, 29 of the writ application, Your Lordship. 29, no?
29.
Clause 15, Your Lordship.
Read clause 15.
Your Lordship, that the settlee shall not transfer, assign, sublet or otherwise part with the possession of the whole or any part of the premises without the previous consent of the board in writing, which the board shall be entitled to refuse in its sole discretion or in its
Event.
or in the event of consent being given, may impose such terms and conditions as it thinks fit, and the board shall be entitled to claim and recover a portion of the unearned increased in the market value, that is, difference between the disposal price, cost price paid, and the market value of the land and premises at the time of sale, transfer, assignment, or parting with the possession. The amount to be recovered being 50% of the unearned increased. The decision of the board regarding the market value of the land shall be final. The board shall also have the preemptive right to take back the premises from the settlee after paying the amount equal to the disposal price paid by the settlee, less depreciation, and 50% of the unearned increased in the value of the land determined in the manner indicated
That's
above,
right.
Your Lordship.
Now, what was the sale was to be, the intention of the animus to sale is reflected by the application made by the appellant, right?
Your Lordship.
And you having consented for the same, you put up a demand in the year 2009. So therefore, the requirement or the stipulation in clause 15 of the agreement is with respect to the intention on that date, whether it was transferred on that date, permission you granted when?
It was to be granted after payments were to be made. That I will read, Your Lordship.
Annexure 6.
I will read, Your Lordship, Annexure 6. Yes, Your Lordship.
24/11/2009.
No, not that, Your Lordship. I'll
Annexure
read.
6.
ताकि वांछित अनुमति annexure 6, the last line, Your Lordship. इतना रुपए जमा करने का कष्ट करे ताकि वांछित अनुमति प्रदान करने की कार्रवाई की जा सके, so that only after you deposit the amount, the decision for decision to give permission for transfer can be given. So Your Lordship, in this case he did it after 2 years, and 2 years time now when he will sell in 2011-12, the next financial year will be applicable, because the amount of the price of the land has escalated. Your Lordship will recollect after 2009-10 the price of the lands in Patna had gone very high, so it is not the boards, it is the market value of the land that was important, Your Lordship.
भूखंड की कीमत के विरुद्ध इतना रुपया जो आपने मांगा है,
That
ये
was
जो-
in 2008-9.
we have followed that.
जी
Why can't you answer the question? You can answer only if you hear the question, no?
जी हुजूर.
ये जो 4,88,136 है, ये सर्कल रेट कहाँ पर है? 2009 का
8-9.
कहाँ दिखाई?
Because the circle rate is an open document, Your Lordship, that is the
It's a
reason why.
figure- It's a
whether-
figure that you've come to.
No, but then that is not in the part of a counter and not the counsel
not
for
in
the
dispute,
petitioners
all right.
operated.
So
Because
now-
objected.
I was saying that that is not in dispute. That's all right. But the amount of 66 lakhs is in dispute.
Because that is a big price now.
That's a
That is
big
it.
amount.
That's why it is in
So
dispute.
therefore, how have you come to that amount?
Market value, whatever the market value was in the government records, Your Lordship. I will bow down to
I'm
this.
asking you for the source.
The circle rate as
Market value कैसे होता है? कैसे decide होता है?
जो
You have an
circle
idea?
rate है सरकार का.
दिखाएं ना, circle rate हमें दिखाएं. That was the consideration. Circle rate was this, and the difference 50%. Circle rate जितना था उतना में बेचे.
Obliged
उसका
Lordship, that
50%
has not,
profit.
that was
तो
not
फिर
asked for.
आपकी notice
He,
नहीं है.
Your Lordship, the counsel for the
Good
petitioner did
enough.
not ask for it. He simply said that it's high, I am not going to pay. It is the 8 and 9 we are paying.
Positive.
The 8-9,
Why
that
will
is,
you say I am not going to pay?
yes, that is 4 lakhs, 2 lakhs,
How
How
whatever.
has the single judge dealt with it? Let us see.
Yes, Your Lordship, I'll come to that, Your Lordship. Both the grounds on which he has allowed, Your Lordship, in my humble submission is not correct, Your Lordship.
देखा जाए हुजूर.
एक बार हम पढ़ ले,
The-
इनको खत्म करने दीजिए.
एक बार पढ़ लेते हैं.
Amount has been accepted by the board, annexure 8.
नहीं नहीं, वो उस पर बहस ही नहीं कर रही है. उस
Your
पर
Lordship,
आपका
I'll come to
dispute
this.
settle नहीं हो रहा है. But बताते हैं.
Your Lordship.
Now, show us from here.
Your Lordship. Your Lordship, from he has dealt in the
Come to
initial
paragraph 5.
5. I have heard the counsel for the parties. I find that the respondent board has not been able to show the additional amount of Labans directed to be recovered from the petitioner was backed by any decision of the board in terms of clause 15. My submission is that there was no requirement for any decision in every case of transfer, since
Now
it is.
we reject that argument for the simple reason that clause 15 is the permissive clause.
You know,
Now you need to take a decision of the board that according to the agreement which was entered into between the board and his father, this was the condition that in case of sale 50% of the market value would be appropriated. So therefore this is a clause which permits.
Your Lordship.
For that a decision has to be taken.
Your Lordship, only after deposit, after acceptance. If he deposits the amount of 50%, then we take a decision that has to be done.
आपने जो वो पहला जो नोटिस 2009 का किया था वो 50% of the amount था.
Your Lordship, that was that. That is the basic.
पढ़िए क्या है, the calculation of the
Your
balance
Lordship,
amount.
I will go by the clause. Clause 15 of the agreement entered between the father of the petitioner and the board in the year 15/10/2005. Your Lordship, 81 agreement, they took possession in 2006, 2008 they want to sell. The calculation of the balance amount of Laban considering the market value of the plot in question in the year 2012-13 is also irrational inasmuch as the petitioner had made a request in 2008, whereas the respondent belatedly sent a letter in 2019
So
requiring.
therefore the request letter was made in the year 2008.
That was
Just a minute. We are not deciding on one particular date. So therefore, please affirm whether the date mentioned in the order is correct.
Your
Now
Lordship.
18/3/2008 is the date when the request was made,
Your Lordship.
right?
Your Lordship.
Now you responded to it
On
Up-
12/5/2009.
second, you responded to it after 1 year and 2 months,
Your Lordship.
okay? And then you asked him to deposit
Certain
again
documents.
on 2009, which was deposited in 2010 and 2011.
And thereafter, demand was raised on 24/11/2009, which was deposited by the petitioner in
Now come to the next
11.
phase. Which judgment has been relied upon by the single judge?
This court finds that the respondent board has relied upon a judgment so and so, so and so, so and so. Your Lordship, this judgment I will show. The last page will help Your Lordship to come to the conclusion immediately, Your Lordship. Or I'll read the entire judgment for Your Lordship.
नहीं, पूरा पढ़ने की जरूरत
ठीक है, तो Your Lordship, only the last I will come. See, page 7 of the judgment, that last page of the judgment. Considering the matter from another angle, the demand of Labhansh was raised on 26/5/2009 by the board. The original allotee expired on 28/5/2009, that is 2 days. The amount in terms of the demand was deposited on 10/6/2009, that is just 15 days after the demand, the Labhansh amount, entire amount was deposited. And an application for transfer of the name and the permission to that effect in terms of the request made by the original allotee was placed before the board on 12/6/2009, meaning thereby that there was no delay on the part of the petitioner in seeking transfer in the name of the heirs. A passage of time of 2 years in completion of the formalities was not vested jurisdiction in the board to enhance the Labhansh, which already stood assessed by the board in terms of the
That's
permission.
right. Your objection to the reliance of the single judge on this judgment is justified to some extent.
Your Lordship,
Now here there was no delay.
no delay.
Now how do you account for the delay when a request was made in the year 2008?
Your Lordship,
You woke up from your slumber only in 2009, and then you asked for documents which was promptly supplied. You demanded money which was also done, right? And then you come up with another demand in 2011, 2009 perhaps, not 11, 2009, and then there was a delayed payment.
Your Lordship, this plot in 2005 actually hire purchase agreement was executed. 2006 possession was given, and the original allotee dies. Now the petitioner steps into the shoes. So what we say that is
We
Bhukhand
will
ke
decide the matter.
Hastantaran, we are asking for the
We will
document.
decide the matter on an absolutely different issue, though we are hearing the appeal. We will say that this aspect has not been taken note of by the learned single judge, though allowing the case of the appellant, that all this calculation is absolutely your brainchild. You don't provide any basis for the calculation. You only talk and clamor about the market value. What is the circle rate? You don't take into account the delay caused by you, but you calculate every day's delay of the proposed seller. Now this is unreasonable. The agreement cannot be construed in such terms where you, being a stronger party, you would call the shots.
Your Lordship, I
Now we will
understand.
decide it like this. Now forget about the reasoning given by the court that in that case there was no delay, it was the delay on the part of the board, and therefore it was not decided. In 2 years' time, from 4,88,000, would the market, 50% of the market value would rise to 66 lakhs. I think
Lordship,
every allottee of the housing board would become millionaire and billionaire with the passage of time.
Your Lordship, Patna has become.
Sorry, you have contributed to it.
Your Lordship, then Your Lordship may observe that whatever the market value for that said year would be
Why
taken.
should indeterminate? We are not going to make an exercise in air, in vacuum.
No,
You
whatever
tell
the
us.
market value is. Your Lordship, then may give me permission for 2
Whatever
weeks,
you do,
I
we are
will-
not satisfied with your demand notice. Forget about the order of the single
Your Lordship,
judge.
but if it has to be in consonance with the circle rate of the
No,
state.
you need to explain what took you so long. 1 year delay because of you, 2 years delay because of him. It cancels out. How have you calculated? I mean, the court has to deal with parties even-handedly.
Even-handedly, Your Lordship.
Right?
it is there.
even-handedly.
Your
तो
Lordship.
आप अपनी 1 साल का कोई प्रीमियम इनको नहीं दिया, कोई कंसेशन इनको नहीं दिया, और इनका एक दिन चून के आपने मार्केट वैल्यू चार्ज कर दिया.
Your Lordship, he will earn
How
profit. Your Lordship.
unreasonable, how unreasonable you have
It is
been.
a case where he'll earn profit. If he sells today, he will get the market price today. Whatever price he will
How?
get
No,
of today.
but
If the land is suppose 70 lakh rupees per katta, he will get.
Just a minute. Suppose you had asked for such money at the time within a month of his making a request to you. Perhaps he would have paid you in 2008 only. Now, why do I account for delay on your part? We ignore that and we take into account the delay made by the.
Your Lordship, one line, because here we say one line, Your Lordship, यहाँ पे हम उन दोनों पार्टी को बोल रहे हैं कागज लेके आइए, हमारे समक्ष उपस्थित होइए and let satisfy us. So it is a process, Your Lordship, which will undergo. It may have taken.
Just a minute, Mr. Singh. Now you have a difficulty in the judgment which has made you succeed. The difficulty with you, Mr. Singh, is this. Now, the judgment which has heavily been relied upon by the learned single judge speaks of a different fact situation, which ought not to have been pressed while deciding this petition, number one. Number two, the argument that you are raising with respect to delay on the part of the board, you never raised it before the learned single judge.
No, it has been noted. I applied in 2008. They took
Maybe.
time.
All right. So therefore, but you made delayed payment after 2009.
No, there is no delay, Lordship.
After 2009.
There is no stipulation कि कितना दिन में जमा करना है.
दोनों चीज तो नहीं होगा ना.
तो ये कहेंगे ना.
मार्केट वैल्यू तो मार्केट वैल्यू डिटरमिन क्लॉज 15 के हिसाब से वो आर्गुमेंट
मार्केट वैल्यू डिटरमिन करके डिमांड कर
दूसरी आर्गुमेंट करिए, वो बड़ा सेल्फ डिफीटिंग आर्गुमेंट हो जाएगा. रीजन इज ट्राई एंड अंडरस्टैंड. नाउ अकॉर्डिंग टू क्लॉज 15 ऑफ द एग्रीमेंट,
Lordship.
are you trying to say that the day when you make a request, that is the day to decide the quantum, the value? No.
No,
It is the day when you sell the property.
They, on
आप वो
2000,
बहस आप you are not understanding. I mean,
Lordship.
you are understanding, but if you carry that argument too far, perhaps you will have to take 5 steps behind.
2009.
According to section 50, clause 15 of the agreement, can you argue that the day I make a request and that request has not been turned down, so therefore that is the year, that is the time when the circle rate has to be taken into account? Do you mean to say this? We disagree with that.
No,
proposition.
I don't say that. I say 2009 you make a specific demand to deposit. I deposit. There is no time stipulation. Now I deposit the entire amount. Annexure 8 Lordship may kindly see, they accept it
His-
and enter the ledger.
That argument we have taken note of.
Yeah.
That argument we have taken note of.
This is afterthought.
No. Afterthought is something else. That we will come to later. You are the difficulty which you are facing, you have to swim afloat. Now, the housing board says, the housing board relies totally on clause 15 of the agreement.
ठीक है.
Right. So therefore, you may have made a payment because there was no stipulation, but such demand notice does not mean that you will take your own sweet time to decide in 10 years.
No, ऐसा नहीं
So
है.
therefore, just a minute,
हाँ.
you could not have, यही तो इसलिए कहा कि वो आर्गुमेंट करिएगा तो जवाब तुरंत आ जाएगा. Now unless you obtain permission, you cannot sell,
Yes.
right?
It's a transfer.
Unless you obtain permission. Now
हाँ.
I'm breaking it in different parts for you to understand that the argument which you are making or which you are contemplating to make, that will make you travel, that will force you to walk 5 steps behind. Now, without the permission of the board, you cannot sell it.
Yes.
Okay?
No, they can only charge 50%.
अब पहले सुन तो लीजिए, तब आप वो बहस नहीं करेंगे. जिस दिन परमिशन मिलेगा उसके या उसके बाद ही आप सेल कर सकते हैं.
जी.
तो परमिशन तो तब मिलेगा when you complete your part, that
Yes.
you make payments.
जी.
ठीक? तो ये पेमेंट आपने 2011 में की.
नहीं, 2011 में नहीं. 2011 में नहीं. Annexure 7 देखा है ना? Annexure 7 हमने जमा किया है.
उस बहस में नहीं जाए
2010 को.
मिस्टर श्रवण कुमार सिंह, उस बहस में नहीं जाए. जिस दिन आप पेमेंट करते हैं, मान लीजिए उस पेमेंट पर ये डिसीजन नहीं देते हैं, तो वी कैन रिलेट इट बैक टू दैट डेट. ओके?
He could reject it. Annexure 7 में जो हम 4 लाख 5 लाख 22 हजार दे रहे हैं, ये उसी दिन रिजेक्ट कर देते
कैसे रिजेक्ट करते
कि
हैं?
you have not paid.
नहीं, आपने पेमेंट किया. एक सेकंड.
Annexure 7 से जब हम पेमेंट कर रहे हैं, they should not accept it. I'm
Annexure
calling
7 से
that.
आप Annexure 7 से कब आप पेमेंट कर?
I'm paying 24/5/2010 को.
हाँ, 5 lakhs,
5,22,000.
not 7 lakhs.
Annexure 7 Lordship, page 40.
ये आप कर रहे हैं 2010 में.
जी.
And then the next page.
एक सेकंड. और दूसरा जो अमाउंट है,
ये हम
कम पैसे वाला 2,82,000,
हाँ.
ये
28
आप
9
2011 में पेमेंट.
28 9
ठीक तो है?
हाँ.
28/9/2011. कैसे आपने कह दिया 11 में नहीं कही? आपने 2011 में कंप्लीट किया. टोटल अमाउंट जिस दिन आप कंप्लीट करेंगे,
जी.
यू एक्सपेक्ट परमिशन,
जी.
राइट?
ठीक है.
on that day, the permission, you were supposed to, I mean, the market price of the property was more.
तो इनका
तो ये बहस आप क्यों कर रहे हैं?
हुजूर, एक चीज देखा जाए, 28/9/11 को हम जमा कर रहे हैं,
जी।
उस दिन इनके हिसाब से जो कह रहे हैं सर्किल रेट पूरे 1 साल का होता है, तो 2010-11
वो बहस तो हमने
हाँ वही कर रहे हैं ना, सर्किल रेट के हिसाब से लगेगा। उसके बाद
वो क्वेश्चन तो हमने इनको कहा है ना कि साहब आपकी बड़ी वेग असेसमेंट है।
उसके बाद हुजूर नोटिफिकेशन,
सर्कल रेट कब से कब का अप्लाई करता है?
खाली सर्किल रेट नहीं हुआ, वो नोटिफाई होता है, बोर्ड उसको एक्सेप्ट करती
वही
है।
तो बात कर रहे हैं ना।
ऐसा कोई प्रोसीजर नहीं, जबरदस्ती मांग रहे हैं। 66 लाख रुपया प्रॉपर्टी का दाम था, 4,68,000 और मांग रहे हैं हमसे 66 लाख।
Where is the circle rate? What assessment? We don't know. For the vagueness of the demand, we are setting aside. We are accepting. Difficulty with the court is that single judge has gone on some decision which is not applicable. नेक्स्ट तरीके से डिसाइड करेंगे तभी। We can relegate ourselves. Now, can we sitting in division bench can always exercise our jurisdiction as if we are deciding it as a single judge matter.
Your Lordship,
We have that law with us. Instead of remanding the matter back to the single judge, we'll decide it singly. We'll decide as if we are sitting singly. No, I was saying we are not getting satisfied by the manner in which you have put up the demand.
Your Lordship, but the only difficulty which Your Lordship is facing, as I understand, is that because what is the market rate, that is not explained.
Not only that. Now you have not taken into account the delay. I mean, 2008 the circle rate would have been lesser than 2009.
Lordship, but the process takes
What
time.
process?
Because we need to understand
so
whether
process,
he's selling
he also
to
takes
somebody.
time to arrange for money.
Your Lordship,
We'll go by this. Then we are not going to interfere with the order.
Lordship,
Tell
at
us,
least we'll take into
make
consideration.
out the case.
Your Lordship, at
Whether
least we'll
whether
make
the
into-
circle
whether-
just a minute, whether the circle rate has been accepted by the board of directors of the housing board.
Your Lordship, because that is the.
Show us the deliberations of the meetings. ऐसे ही आप कुछ कह देंगे उसको थोड़ी मान लेंगे.
No, Lordship, it is a part of the agreement. He has signed that 50% of the market
Agreement
rate.
is permission, I have told you. That's a clause which permits you to charge.
Your Lordship.
But what amount would you charge? You need to give the calculation. How many times will I say the same thing?
Your Lordship, my submission is that it is the circle rate of the state government which we take into consideration
No.
while calculating.
Circle rate as on that date, which is applicable for what tenure and how have you calculated? Sorry, we are affirming the order unless you give us the details.
Your Lordship, then I'll
उसके
need
पास
4
है
weeks
नहीं
time.
डिटेल,
नहीं
कोई
देंगे तो।
डेलिब्रेशन आता है, कोई काउंटर में ये बात नहीं है ये। अब बोर्ड का भी कोई डिसीजन नहीं है, सर्किल रेट से नहीं होता, बोर्ड हैज टू डिसाइड द प्राइस, द क्लर्क कैन नॉट डिसाइड द प्राइस इन द ऑफिस कि ना ये रेट लगेगा वो रेट लगेगा।
Right?
Your Lordship, whatever will be the circle rate, Your Lordship may hold that 50% of that the board is to charge, Your Lordship. At least this much, Your Lordship will appreciate that if
Where is
50%
board?
of the.
Your clerk is deciding, there is no board. Board means board of directors.
You will see in the judgment that in Your Lordship to the 2024 Supreme Court, Your Lordship, cases page 136, Your Lordship, it has been held that we can board can charge 50% of the market value of unearned profit, Your Lordship. I rely on the judgment, Your Lordship.
No, we are not getting inclined. Now come to page 29 of the writ petition.
Your Lordship. Your Lordship.
Last 1, 2, 3, 4, 5, 6, 7, 8, 9. Ninth line from the bottom.
Your Lordship.
The decision of the board regarding the market value of the land premises shall be final. Where is the decision of the board taking into account the circle rate of which year? कुछ नहीं है. ऑफिस में डिसाइड कर लिया बैठ के कि 60 लाख रुपया मांगना है.
Your Lordship, if I may given a chance, Your Lordship,
Why?
since Your Lordship is hearing
Why?
the matter as deciding it
Have you given permission to him to sell?
only after deposit of the
So therefore he has lost his customer.
he will get customer.
He has lost his customer. Then what is the demand now? Where is the demand now? He is not selling it. You have not sold it, no?
No.
So
So
where is
the-
the demand now?
So Your Lordship, if he doesn't sell it, it's okay, Your Lordship. Then there is no question
So
of.
he has lost the customer today.
So Your Lordship, if at some date he doesn't want to sell it and wants to stay, Your Lordship,
I
the
don't know.
board
We don't
would
know.
not-
You have created a situation whereby he could not sell his property. Make a statement that you have not sold the property. This demand goes. Mr. Shravan Kumar, you can take a call.
Lord, so far he was
Take a situation. Now,
ट्रांसफर तो नहीं हुआ है ना, कुछ कंसिडरेशन तो पास हुआ होगा, लेकिन फाइनल रजिस्ट्री तो नहीं हुई ना उसकी. अब वो can't be reversed. I can't sell it in open
Mr.
market.
Shravan Kumar, if you have settled the price with somebody, it would be better for you to back out because you don't have the permission.
No, I can't back out.
That means you have sold it.
That is dishonest.
You have sold it.
No, it has to be registered. It's
Behind-
only legal sanctity.
हाँ, उसमें वो आपका जो वेंडी है वो रह रहा है. And he is pressing you hard for getting it registered.
नहीं, उसमें तो देखा जाए दोनों पिटिशनर है इसमें. एक पिटिशनर में
Would
दोनों.
the appellate court not be justified? Would the appellate court be highly unjustified in taking a statement from you that you have not sold the property?
No, I am not saying that I can't say, because some consideration may have passed, but final sale will occur only after the registry is done by the board. Otherwise, there is no sanctity to the transaction.
Look here. Now we are giving you one opportunity. You tell us whether it is the decision of the board, and it has not to be post this order. Unless you place it on record, we will sustain the order of the single judge, and you do it within 1 week.
In 2 weeks, Your Lordship.
Look here. The learned single judge, SL, the appellant, Housing Board, the appellant Housing Board, for granting permission to the respondent / allottee to sell off his property, put up a demand of rupees 66,76,499, which was challenged by the allottee / respondent allottee by CWJC number 414831 of 2014. First up, the learned single judge, by his order dated 27/8/2019, quashed the demand notice on the ground that in the first instance, on a request of the allottee to seek permission for transfer of the property in question, which was made on 24/11, which was made on, what was the date when he made that, when you made that request?
It was
8/2008, something like this. It's not very clear in my page. In extra 5, Your Lordship.
Which was made on 12/5/2000, no, which was made on 12/5/2009. No. कौन डेट को आपने रिक्वेस्ट लेटर भेजा था? You had said that date sometimes.
An extra 5 mentions about that letter, Your Lordship. The second line, Your Lordship, an extra 5, second line. ये आपका आवेदन दिनांक 18 कितना 2/8 वो मेरा क्लियर नहीं है लॉर्डशिप।
18/3/2008, 18/3/2008।
लिखो पर क्या लिखा पर ऑल राइट। 18/3/2008, the Housing Board responded on 24/11/2009, asking the allottee / respondent to pay a total amount of rupees 7,70,361, which ultimately was paid by him finally by 28/9/2011. First off, some amount was paid on 24/5/2010, and the rest of the amount was, as noted above, was paid on 28/9/2011. The Housing Board thereafter, while demand notice dated 10/7/2014, asked the allottee / respondent to make payment of rupees 66,76,499, as with the passage of time the circle rate had risen and the amount which was fixed by the Housing Board earlier was not sufficient. The learned single judge found that such enhanced demand notice was not backed by any decision of the board. Even the calculation was left vague, and the allottee had no idea as to how the price, as to how the amount was fixed, as to how the quantum was fixed for grant of permission to sell the property. We have perused the agreement between the Housing Board and the father of the allottee. Clause 15 of the aforesaid agreement specifies that the settlee would not transfer or assign or sublet any part of the property without previous consent of the board in writing, which consent could be refused by the board in its discretion, or could be granted subject to imposition of terms and conditions which the board would have thought fit, and the board would also be entitled, in that event, to recover a portion of unearned increase in the value, that is difference between the disposal price / the cost paid and the market value of the land and premises at the time of sale, transfer, assignment, or parting with the possession. The amount so recovered would be 50% of the unearned increase. The clause referred to above further specifies that the decision of the board regarding the market value of the land / premises shall be final. The board also has a right to take the board also has the preemptive right of taking back the demised premises from the settlee after paying an amount equal to the disposal price paid by the settlee. after depreciating the 50% of the unearned increase in the value of the land determined first off. Next, we have also perused clause 16 of the agreement, which provides the manner in which such assessment of market value is to be made. First off, the settlee would be under an obligation according to the agreement to permit a staff of the board having jurisdiction over the area to enter the premises in the manner indicated. We have 16 choice. The Land Council for the appellant has submitted that admittedly the payments were made in the year 2011, on which date the circle rate had gone high, and therefore the earlier assessment of the board was inappropriate. Inappropriate.
Lordship, may I kindly permit me to say a few words. He is asking rate of 2012 and 13. The money has been deposited in 2011 itself. So even according to their assertion, the rate of 12 and 13 will not apply.
नहीं वो ठीक है, वो तो इनकी बहस पहले कर लेनी चाहिए तब आप क्या लिखा है पूरा? Such a communication was made by the board in the year 2014. In the year 2014. The other argument raised on behalf of the board is that the learned single judge relied upon a decision of a coordinate bench of this court in CWJC number 338 of 2013, which did not permit any enhanced charge on the ground that the delay in payment of such amount was not at the instance of the settlee but of the board. First off, the situation, it has been argued in the present instance, is just the opposite. First off, as such, it has been urged that the learned single judge was not justified in quashing the demand notice. First off, additionally, it has been argued that the housing board is ready for issuing a fresh demand based on the market rate. You're not ready for this. Based on the market rate. No. That you will not.
Because I have to take
All right.
instructions what this
First off, as opposed to the aforesaid contention, Mr. Shravan Kumar Leonard, senior advocate for the allottee/respondent, has submitted that the board conveniently forgot about the request made by him in the year 2008, for which a demand notice was made on 24/11/2009, which was partly paid on 24/5/2010 and thereafter on 28/9/2011. If the board was not satisfied with its own assessment of the amount which the settlee was required to pay before parting with the property, such a decision ought to have been made by the board immediately. That the board prevaricated and responded in the first instance after about 1 year and 2 months, and then after approximately 3 years when the payments were made, any claim for enhanced payment by the board would be highly unjustified. First up. It has further been argued by Mr. Kumar, learned senior advocate, that even going back to the terms of the agreement, especially clause 15 thereof, such assessment of the amount to be paid by the settlee before parting with the property, the board has to take the decision about the quantum of money to be paid. First up. In the present instance, there is no decision of the board accepting the circle rate of a particular year to be the current rate for calculating the amount payable by the allottee. It has also been submitted on behalf of the respondent that in the absence of any such calculation having been shown to the noticee / respondent / allottee, the demand was rightly quashed by the learned single judge. He further laments that had a decision by the board been taken immediately after a request was made on his behalf, the property would have been sold by that time, and the respondent would have been ready to part with 50% of the unearned increase. There has been an unusual delay on the part of the housing board to respond to the aforesaid request, but in a most arbitrary manner, the delay in making payment by the allottee is being taken advantage of by the board in enhancing the quantum 100 times, and that also without referring to any circle rate prevalent for the time for such enhancement. Even the second notice of the enhanced amount, it has been reiterated, was served upon the respondent after 3 years of his depositing the money, of his having deposited the earlier assessed amount, of his having deposited the earlier assessed amount. These background facts thus disentitle the appellant housing board to demand any money for granting permission to the settlee to part with his property. Ms. Vinita Singh, learned counsel for the appellant, seeks a short time to bring on record the circle rate which has been relied upon, for calculating the quantum of money which the settlee would require to pay before getting permission for selling the property, and whether any decision had been taken by the board that time, whether any decision of the board had been taken by that time in its deliberations, in its in-house deliberations.
Produce the record. They will start
In the in-house deliberations, and the record reflecting such deliberation, and the record reflecting this that deliberation. Re-notify on 2 weeks ka samay. Otherwise, we'll quash it.
The original records have to be produced.
No, you give the photocopy, we'll accept it. There has to be a decision of the board that this is the circle rate, and therefore a decision to charge him with this amount.
13 of July.
Next. 115. कॉल करिए, एक कॉल करिए.
719, Mr. Mrityunjay Kumar.
2014 दोनों का रिकॉर्ड मांगा है.
अरे आप इतना काफी है, इनके पास डिसीजन ही नहीं है. Why are you worried? The judgment, the difficulty is that a judgment you showed to the single judge which does not apply to the facts of your case. Therefore, we are entertaining this petition.
एक हुजूर एक लाइन अगर हमको कहने दिया जाए.
बोलिए. आपने जो नहीं कहा है वो भी बहस लिखा दिया है, फिर आप कौन से एक्स्ट्रा लाइन?
2011 में हम पैसा जमा कर दिए।
वो तो लिखा हमने।
नहीं, 2000 में कर दिया, और ये सर्किल रेट मांग रहे हैं 12-13 का।
एक मिनट, you're right. तो ये हम अभी कह देंगे तो आप जान गए कि सर्कल रेट 12-13 का है, then that argument would
ये मांग रहे हैं 12-13 का।
देखिए, Mr. Shravan Kumar Lund, senior advocate, has further stressed the point that notwithstanding the respondent having paid the amount in the year 2011, the further demand is perhaps based on the circle rate of...
Clearly, perhaps.
अरे वो perhaps लिखना बड़ा मुश्किल है. Is perhaps based... There is a reason why I have used the word perhaps. Have they said so?
Yes.
Where?
Annexure 10.
Annexure 10 में लिखा है.
हाँ, 12-13 के हिसाब से इतना देना होगा।
वो भी लिखा है 12।
हाँ, बिल्कुल।
क्या लिखा है?
अब कुछ बचता नहीं हो जो इनको
कुछ नहीं बचता है।
टाइम देने का।
नहीं, टाइम तो हम देंगे चूंकि आपने रॉन्ग जजमेंट अप्लाई करा दिया।
तो अलग बात है, लेकिन 12-13 का इनका डिमांड नहीं है।
A further demand has been raised on the basis of circle rate of 2012-13, 2012-13, which ought not to have been the basis for calculating
Yes.
any enhanced amount
जी।
for granting permission to sell the property.